You haven't been in court yet.
Oh, Miss, you were in court on June. All right, this isn't the, is this?
This is the same case that we had on Friday.
All right.
I recapitulate a little bit what happened.
Sure.
He got probation on bars number 2025 CR 002719. After he had pled, but before he was sentenced, they filed an indictment which was coming out of the same fact pattern, theft case, which is 2025 CR 007197. So I've conferred, and I believe that they are willing to TIC that case if they could add conditions to his probation for any possible restitution that would have arisen out of that case.
Okay. So let me pull up the other case. And that's 2025 CR 0027.
002719. That's the one that he pled on, that you gave him probation. No, excuse me.
That's this case.
Yeah, 7197. That's the one that was indicted. He's before the court. The one he got probation on was 2719.
All right.
Yes.
So what are you all requesting?
If the state had known about this case, it probably everything would have been resolved.
Mhm.
So in order to move forward with the TIC, have probationer go on probation, which is what the court parties were wanting, we would want to amend and alter conditions to reflect what would have been done at that hearing had we known about this case. And so if we're able to add conditions to the case for which probationer was granted probation that reflect items for this theft case we want a TIC, then we would be able to resolve everything today.
Okay. Yaya, can you have them bring out this file for me? 2025 CR 002719. All right. So do you understand what's happening?
Yes, ma'am.
And are you in agreement to that?
Yes.
All right. We'll go on the record. The court is, and Ms. Abrams, this is a motion to revoke. Well, not a motion to revoke. It's an amendment of his probation. It is Wilfredo Matti, Mattei. All right, the court is calling 2025 CR 002719 State versus Wilfredo Matti. Can I have parties announce?
Duffy Pitlock for the state of Texas, Your Honor.
Brian Kimbrough for Mr. Mattei.
And are you Mr. Mattei?
Yes, ma'am.
All right, and I'm so sorry, I forget. Is it Mattei or Mattei?
Mattei.
Mattei. All right. Mr. Mattei, you're currently on probation out of this court. And both parties off the record have informed the court that this new case appeared. It's 2025 CR 007197. And both parties have agreed that the state would take this case into consideration and add conditions to your probation and cause number 2025 CR 002719 to include any restitution amount that's owed to the complainant in 2025 CR 007197. And the complainant in that case would be U-Haul. Did you understand?
Yes, Your Honor.
And is that the agreement from the state and the defense?
In addition to restitution, the state would be asking for no contact.
All right. And also no contact with U-Haul.
Is that every U-Haul
Yes,
in America or in Texas?
that's every U-Haul. So you're going to have to do it the way we did before there was a U-Haul. You call your friends, you see who has a truck, right? And that's what we would do in the past.
No U-Hauls.
Okay.
All right, so, is that the defense and state's agreement?
Yes, Your Honor.
That is, Your Honor.
All right, Mr. Matei, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Wilfredo Matei.
All right, Mr. Matei, did you understand the agreement that's been reached between yourself and the state?
Your Honor.
And are you in agreement to that?
Yes.
And you understand in cause number 2025 CR 007197, you have a right to a jury trial if you so wish.
Yes, Your Honor.
And do you wish to have a jury trial in that case or no?
No.
All right. So then the court will accept the dismissal from the state without objection.
No objection.
And as previously stated, your conditions and cause number 2025 CR 002719 will be altered and amended to include restitution, if any, to U-Haul, and cause number 2025 CR 007197, and there's to be no contact with U-Haul. Is there anything else from either side?
Nothing further, Your Honor.
Not from the state, but if the state may tender.
Thank you. And probation will go over your conditions with you. And we're off the record. Counsel, do you need a setting for a restitution hearing with regards to that? All right, thank you.
Thank you.
Thank you.
Court is calling 2021 CR 11807 State versus Raul Jacob Fernandez III. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Peter Calderola standing in for Gail Calderola for Mr. Fernandez, Your Honor.
Are you Mr. Fernandez?
Yes, ma'am.
Do you have any objections to this attorney standing in?
Just made a mistake and
No.
no,
Any objections?
I mean, if you have,
no, man, no, man, no, man.
all right. Did you review the motion to revoke community supervision and state's motion to supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Raul Jacob Fernandez III, guys, we're on the record, who was placed on community supervision in 2021 CR 11807 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on February 15th, 2022 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bexar County, Texas, the defendant Raul Jacob Fernandez III did then and there fail to report to the supervision officer as directed for the months of March through December 2022 in violation of condition number 4.
All right, to that, how do you plead? True or not true?
The state will waive and abandon the remaining violations, Your Honor.
No objection, Your Honor.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 4 years in the prison
Yes, ma'am.
and up to $1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
No.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Your Honor, we don't have an agreement, but we have proposals.
All right, state, what are you requesting?
We are requesting that you grant the state's motion, revoke probationer, sentence probationer. The state recognizes you have 4 years. State is asking for 3. The state will tender TICs for 2 new number 1s at the resolution of this matter.
And Judge, that we're following that proposal.
Oh, you all in agreement to the 3 years?
Yes.
Yes, Judge.
All right, sir, are you waiving your right to appeal?
Yes, ma'am.
And are you asking the court to follow this agreement?
Yes, ma'am.
And what cases are being taken in consideration?
Possession of a controlled substance.
The cost numbers.
Oh,
if you
sorry,
have
Your
them. That's okay.
Yes, we have 2025 PF 23502.
Mhm.
And the second one, 2025 PF 23503.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed. Oh, I'm so sorry. Just one moment. The court is going to grant the motion, find violation of condition number 4 true, revoke, sentence you to 3 years in the prison, give you credit for any time served, take in consideration 2025 PF 23502, 2025 PF 23503, and the court will request the therapeutic community. All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So why were you not successful?
I just messed up, ma'am. Sorry.
No, I understand that sometimes things happen, right?
No.
So here's the thing. It appears to the court that you may have a drug issue. You need to make sure that you take care of that. You'll request the therapeutic community. I have no jurisdiction to have them force you into the program or order them for you to be in the program. But if you don't ask for it, they definitely will not put you on the program. Once you're released from prison, if you can't find a sober support home or somewhere to stay or help with your addiction, you can come back to court. If I'm still here, I get you the help. You understand?
Yes, ma'am. Thank you.
Because the last time you use may be the last time you use, and only 2 things are going to end up happening in your situation. Either you're going to end up in and out of prison or in and out of jail, or either it may be the last time you use. You understand?
Yes, ma'am.
All right. Good luck to you, sir.
Thank you.
You're welcome.
Thank you, Judge. Are you
Thank you.
excused?
Yes. Hello.
Hi.
All right, the court is calling 2025 CR 007106 State versus Christina Louise Shad. Is that how you pronounce your last name?
Yeah.
All right. That party's announced.
Duffy Pitlock for the state of Texas, Your Honor.
Jay Moritz, Your Honor, from the shop.
And are you Ms. Shad?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Shad, did you review the indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Shaw, did you review the court admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
I'm sorry, is the court admonishments
It's this document. It tells you everything, what you're charged with, and it tells you the range of punishment, and it tells you what your rights are.
Okay.
Did you review that with him?
Yes.
And did you understand it?
Yes.
And did you sign it in all the appropriate places?
Yes.
All right, so you're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from a $10,000 fine and anywhere from 180 days up to 2 years in the state jail facility. If you have a plea with your attorney and with the state, the court does not have to follow that agreement. If for any reason the court does not follow that agreement and give you more than you bargained for, the fact that you've entered a plea will not be used against you, and we can start over. Do you understand?
Mhm.
And you can withdraw your plea. Do you understand?
Yeah.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Mhm.
Did you understand that?
Yes. Yes.
Did you understand by entering this agreement, you're giving up those rights?
And
You understand that you're given the rights to a trial by jury?
yeah.
All right, so I'm going to take it step by step. And has she been before me before? Why do I remember her?
No, this is the first time. She had some cases years ago where she was ruled incompetent.
Okay. All right, so you have a right to a jury trial. Do you understand?
Yes.
All right, so what that means is 12 people would sit on a jury. 12 people, neither you or the state knew beforehand. And the state would call witnesses. Do you understand?
Mhm.
You're going to have to say yes or no.
Yes, ma'am.
Right. And the state would call their witnesses, and then your attorney would be able to ask them questions, or you could ask them questions. Do you understand?
Yes.
All right. So because you're entering this plea bargain agreement, the state is not going to call any witnesses, and your attorney is not going to have a chance to question any witnesses, and you won't be able to question any witnesses. Do you understand?
Yes.
All right. Do you understand that if the state were to call witnesses, the state couldn't say, I'm going to call Ms. Schott as a witness. So do you understand that?
Yes.
So you're giving up your right to remain silent also by entering into this plea bargain agreement that you've reached. Do you understand?
Yes.
So do you want a jury trial? Yes or no?
And
All right. Counsel, has your client been able to provide you with any defenses?
Yes, Judge, I've had a Zoom with her at the jail and we discussed things.
Do you believe she has a rational, a factual understanding of the charges against her?
In my opinion, at this time, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Judge.
Ms. Schott, has anyone threatened you, forced you, or coerced you to get you to enter this plea?
No.
Anyone promise you anything other than the plea bargain agreement that you've worked out?
No.
Are you satisfied with the way you've been represented?
Yeah.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
All right, so this is what I'm being told your plea bargain agreement is. It's 180 days in the state jail facility. You're not applying for any type of probation. And there's to be $60 to be paid to the Bexar County Laboratory. Did you understand that?
Yes.
And that $60 is what they say it costs for them to do the drug testing. Did you understand that to be your plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, it is, Judge.
Did you review the waiver of appeal paragraph with your attorney?
yes,
Did you sign it in both places?
Yes.
All right. So by signing that, if I follow this plea bargain agreement, you can't come back later and appeal that. Do you understand?
Yes.
The only rights you have to appeal is if your attorney has filed pretrial motions, such like maybe a motion to suppress or something like that. And I've made a ruling on that. Do you understand?
yes,
Counsel, have there been any motions that you filed where the court has made a ruling on them?
No, Your Honor.
All right. Then to the charge, how are you going to plead? Guilty, not guilty, or no contest?
no contest.
All right. State, any evidence?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
No objections, Your Honor.
Thank you. All right, did you review the stipulations and waivers with your attorney? That is, it consists of police reports, the reports from the chemist on whether or not the drugs tested positive for any type of drug. Did you review those documents with your attorney?
Yes, yes,
All right. So I just want to make sure you understand. The state is presenting their evidence now by not calling witnesses. They're just bringing in police reports for the court. Do you understand?
Yes.
Now, if you want to, you can force the state to bring in witnesses to say that you committed this offense beyond a reasonable doubt. Do you understand?
Yes.
So do you want them to present witnesses or no?
Yes.
All right. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
yes,
Yes.
All right, anything you wish to say on behalf of your client?
No, Judge, we've gone over this and at the time of the incident, it appears that she was under the influence of narcotics. I've conferred with her and believe that she understands everything that she did, and her competency is intact right now.
All right, the court is going to sentence you to 180 days in the state jail facility, give you credit for any time served. The court will request the therapeutic community. There's to be no contact with the Valero located at 12111 O'Connor Road San Antonio, Texas, 78233. And there's to be restitution to the Bexar County Laboratory for drugs testing in the amount of $60. Is there anything else with regards to sentencing?
No, Judge, she's been in custody since 4/16/25. We're asking if she would, if she gets, or if you get the paperwork from the state jail facility to allow the 80/20 credit.
All right, what will end up happening is that's going to depend on any programs that you're participating in. If you're participating in the programs and internalizing everything, I will strongly consider giving that to you. So whether you receive that or not will be completely up to you and your actions. Do you understand? Yes or no?
Yes, ma'am.
Okay. Did you review the trial court certification of defendant's rights to appeal with your attorney?
The one you signed.
Yes.
That's right.
All right, because you entered into a plea bargain agreement, and because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. So here's the thing, Ms. Shaw. It appears to the court that you have a drug problem, right? When you are released from custody, if you cannot find a place, be it a sober living house, or if you have a problem with your sobriety and you just need some extra help with it, if I'm still here, you can come back here and I'll pick up the phone and find a place for you, okay?
Okay.
So only one or two things can end up happening if you continue on this path. Either you're going to end up in and out of somebody's jail or prison, or either somebody's going to have to identify your body. You understand?
Okay.
And I don't want that for you, okay? All right, good luck to you.
Thank you.
You're welcome.
Good luck.
Page is on. Just give me a moment.
Sam.
So this is motion for early termination?
Yes, Your Honor.
All right, and state, are you opposed to the early termination?
The state is not opposed, Your Honor.
Oh, okay,
Always a bonus.
yes,
I have checked in with your probation officer and I'll let her speak for herself.
yes.
Judge, I did check in with the CSO and he says that the probationer has been doing great. He feels like he has been rehabilitated. He has not had any compliance issues and he's in support of the early termination.
All righty. So here's the $1 million question. What have you learned?
Not to be causing mischief and corruption, not doing drugs, trying to work better with my record is difficult to get a job. I've been doing temp services and but yeah, being productive citizen, that's what I've learned.
All right, so this is what I'm going to do. I'm going to follow your agreement and probation. If you can contact Deanna, they usually have specific places that will hire people who have criminal history. And so make sure you contact them. If you contact them, they'll probably be able to have a job for you probably by the beginning of next month.
Okay.
But here's the thing. I always tell people wanted to be president of the company. You got to start somewhere, right?
Yes, ma'am.
So the key for you is let me just get a job to support myself and you can still keep looking for other things.
Would it be possible to get it off of my record?
Oh, you'll have to
talk
speak
about
to your
that.
attorney about
Okay,
that.
all right.
All right. Good luck to you. Congratulations.
Yes.
Thanks for turning your life around.
Thank you.
I appreciate you. Thank you.
All right. You're welcome.
Thank you, Judge.
Right,
May
thank
we
you.
all speak, excuse?
Yes. Well, wait till he gets the information so that we can make sure he has employment.
Yes, ma'am. Thank you very much, Your Honor.
You're welcome. Hello, good morning. One moment. Yeah, that's-
Thank you, Judge.
You're welcome. And this is your first setting?
No, we've been
No,
here
it's not.
a few
Okay.
times, Judge. We are here on a setting where the state has given a new offer that we'd like 30 days if the court will give us time to consider this new offer, which is significantly better.
All right, I tell you what, I'll give you 3 weeks because we were actually scheduled for jury trial and today is for us to obtain a new jury trial date. So I really recall that's back in 3 weeks. That will be your final plea deadline date.
Understood, Judge.
All right, Ms. Ferguson?
Yes.
I need a 3-week reset for a plea deadline date, and this is the final plea deadline date.
That's fine.
All right, once you sign the reset. All right, so we need a jury trial date.
Yes, ma'am. And Mr. Chapa is here to present himself to this court. He did this court last week. We were vocal with him through that process. He had some car trouble that day. If Your Honor will look at the case file, he has not missed this. We have not had any issues out of
Right,
him.
so here's the thing. He'll need to go in custody, and if you want to call the bondsman.
The bondsman is here and he is willing to remain on the bond, Your
All
Honor.
right, where's the bondsman?
Amanda, you might just step right
Yeah.
out.
All right. The document I have from the bondsman is a motion to increase bond.
Mr. Fernando is the bondsman, Your Honor.
All right.
I know him.
Oh, great. I'm familiar with the Birmingham Black Barons from days of old, from history. All right, so with this case, I received a motion for a request for a bond increase. You're no longer requesting that?
No, ma'am.
All right,
And I have a motion for the reinstatement bond if I have to,
all right,
but I'm willing to stay on this bond.
all right. So, state, the court is looking at the docket sheet. He's always been here. Do you have any objection to the bond remaining the same?
We do, Your Honor. He was set for trial and failed to appear at that trial date, and presented a flight risk to this court and to the state, showing the court that when it's time to go to trial, he's not going to be here. And so for that reason, the state would request that he be remanded without bond. And if the court wasn't planning to set a bond, then the state would ask for $200,000, which would be, I believe, $115,000 more than his original bond.
All right, so we're going to go on the record, and Mr. Rocha, I'll note that you have no objection to the bond being reinstated. So let's see what happens with this hearing.
Yes, ma'am.
All right, thank you.
Thank you.
Court is calling 2024 CR 009634. State versus Baldemaro, Joseph Chapa. Can I have parties announced?
Ashley Jones for the state.
Dante Dominguez for Mr. Chapa.
And are you Mr. Chapa?
Yes, ma'am.
All right, so state defense hasn't filed a motion for reinstatement of the bond, but the court will note for the record that the bondsman has presented the court with a document asking that bond be reinstated. And it's the court's understanding, state, you're in objection?
We are, Your Honor. The state just would like the court to note that the case was set for trial, and at that trial date, this defendant failed to appear, showing the court that he has no intention of appearing when it's actually set for trial. And so for that reason, the state would request that the defendant be remanded without bond. And if the court is inclined to set a bond amount, the state would recommend 200,000 and full house arrest GPS.
All right, so yes, if you'll address the issue of him not appearing.
Yes, ma'am. It was last week, I believe it was last Wednesday, or it might have been Tuesday, but he did not appear. It was a car issue. He did attempt to come to court on Thursday. I was vocal with him that day. As Your Honor will remember, I believe you were in trial on that day. And your clerk said that Monday morning would be the best opportunity to be able to flesh this out with the short hearing that we're doing now. So that was my suggestion to him, and he did make himself available that day. I have also consistently been speaking to his bonds person who the court has heard from this morning as well. He is going to stay on it. Now, I have not had a problem contacting Mr. Chapa through the tendency of this case, and this is the first time he's ever raised a court date.
So why didn't he appear? I understand the state's argument that it was scheduled for jury trial. So the question is, if he had car problems, then why didn't he still appear later?
We do not have a good answer for that, Your Honor. He missed court, and we can't make him be here for it.
It was a bad day. My steering wheel got like locked. I broke my key trying to unlock it. My phone died. I didn't have no way to charge it. I started walking, tried to get to a phone so I could call my mom. My mom actually had already left to come here, because if not, she would have gave me a ride and I would have been here. It was just one of those horrible things. You know, I've never missed anything when it comes to court, ma'am. I always show up. I'm always proper. I've never had any problem.
And I can tell the court that his mother was here on that court date, Your Honor.
No, I remember his mother was present, but she's not scheduled for trial.
Yes, ma'am.
All right, this is what the court is going to do. The court is noting that the defendant has appeared for every setting besides that specific setting. And he has been scheduled for jury trial more than once, and he's appeared when that jury trial was set. Sometimes there's a lot that happens and it hits somebody all at once, and the court is understanding of that. The court will reinstate the bond. The bondsman has agreed to have the bond reinstated. The court is going to give you all a jury trial date if you'll confer with the state, and that will be your jury trial date. This is what I want to stress to you. And we can go off the record. There are not to be any other things piling on top of each other where you don't make it for court. You have to have backup plans. I understand when a steering wheel gets locked. That has happened to me before, and guess what? It's not unlocking. All right. So he can be released. I'm going to sign the motion to reinstate the bond. Yes, recall the warrant. And bondsman, if you'll give me the documents for the reinstatement of the bond, please. And if you all will confer with Ms. Ferguson on a jury trial date for dressing appropriately for court, just have a seat.
Thank you very much, Your Honor. And once we get that date, maybe you see us.
Oh, you'll have to tell me. All right. So in this case, we're here for discovery. Where are we on the discovery issues? Home surveillance from complaining witnesses' phone.
Your Honor, we did speak with the complaining witness's family on Friday, and we are in the process of getting that information. We did get other recordings that we provided to defense this morning, and counseling methods we have received, and they're just in the process of being uploaded. We just need a little bit more time for the home surveillance.
And then was it that the counseling records were sent and under pending transmittal?
Oh, yes, Your Honor. So we've received them. They're just waiting for a paralegal to upload.
Okay, so the only thing that's outstanding is the home surveillance?
Yes, Your Honor.
And I did want to add an ethical disclosure regarding
yes.
a potential witness.
And I'm sorry, what else?
And an ethical disclosure regarding a potential witness.
All right. All right, how long is it going to take you all to have that?
Your Honor, it shouldn't take very long at all if the complainant Mrs. Miller has it, she'll send it over to us. And the state is prepared to make an offer or has made an offer to defense.
All right, Ms. Ferguson.
Yes, sir.
3 weeks for a final discovery, please. Is that good for your counsel?
Yes, I believe so.
All right, so August 11th. Is there anything else?
Not from the state judge.
All right, thank you.
Thank you.
Thank you.
May we be excused?
Yes. Application?
There's none, Judge. It says.
Oh.
It's cap offer.
All right. And are you going to ask for, do you need a PSI and tap or do you just need a reset for?
Like a PSI, Judge.
All right, what date for a PSI? And is there going to be any mental health, a MIC evaluation or no?
I don't anticipate that, but I will have a witness to that effect.
All right. All right. Ms. Abrams, this is going to be September 15th for a PSI. Court is calling 2025 CR 001248, State versus Lynn Wayne Morin. Can I have parties announced?
Samantha Lynn Brown for the state.
Louis Martinez on behalf of Mr. Moore.
And are you Mr. Morin?
Yes, yes.
Counsel, have you received all discovery? Did you review that with your client?
Yes, Your Honor. The discovery that I could review with him, I reviewed with him.
Court will find that the state is in compliance with discovery. Mr. Morin, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Morin, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, you're charged with possession of child pornography with a child younger than 10 years of age. As a first-degree felony, the range of punishment is anywhere from 15 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand?
Yes, Your Honor.
By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Just one moment off the record. Yaya, can you make sure these are file stamped so that the defense can have their motions to seal?
Yes. Yes.
We're back on the record. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Morin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
That's your copy.
Thank you, Your Honor. You're welcome.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to your plea, your punishment is to be assessed at a cap of 30 years in the prison. There's a $5,000 fine. There are no applications in Chapter 62 compliance. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and voted upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
State offers States Exhibit 1 and all attachments and States Exhibit 2 and its contents. And at the same time, I would move for that motion to seal to be signed for the contents of States Exhibit 2, which contains the child pornography images in this case.
That's all without objection, Judge.
All right. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Did you understand that there are certain documents that contain child pornography that your attorney and the state have agreed that that would be sealed?
Yes, Your Honor.
And did you understand that in order for it to be unsealed, someone, an attorney or a party, would have to file a motion and have a hearing, and the court will make a ruling on whether or not to unseal that?
Yes, Your Honor.
So after today, do you understand that that document or those documents will be sealed, and those documents will not be accessible to the court or to the state or to the defense or to you? Do you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. This will be set for sentencing on September 15th. Once you sign the reset form, you will be excused. And if you'll talk with probation, they will do what's called a PSI investigation. It's not for purposes of probation. It is merely for me to obtain more information about you. Do you understand?
Yes, Your Honor.
All right, thank you.
And Judge, just
Yes.
really quick, did you admit State's Exhibit 2 as well, which is the sealed?
Yes.
Okay, perfect. Just want to make.
Thank you.
Thank you, Judge.
All right, thank you.
Thank you, Your Honor.
No, just a PSI.
Thank you, Judge. May I get these?
Yes. Court is calling 2025 CR 002989, State versus Maverick Dennis Ennis. Can I have parties announced?
Deputy Pitlock for the state of Texas, Your Honor.
John Robertson for Mr. Ennis.
And probation, this is an application. All right. Are you Mr. Ennis?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Ennis, did you review the application for community supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Ennis, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with the offense of criminal mischief, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call them the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am. I fully understand.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Ennis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am, under no circumstance.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Fully.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. The state recommends community supervision. They're taking in consideration 2025 PF 12413, 2025 PF 12414. There's to be restitution to Cornelius Meister, Meister, Marlene, Marlene, Pollard, Pollard, and 2025 PF 12414. There's to be MRT, no contact with the complainants, TAP evaluation, and follow all recommendations. Did you understand that to be the
Yes,
plea?
ma'am, I fully do.
Defense?
Yes, sir.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, I fully did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
Oh, yeah.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation, 100 hours of community service restitution, and no contact with the complaining witnesses. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
No more fouls, please. All right, I'll pick it up after lunch. All right, state, any evidence to support the defendant's plea?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I fully understood.
Again, did you understand you have a right to jury trial and the right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, sir.
All right. So it says damage to a vehicle, $3,609.22. Are you all agreed to that amount or no?
It appears that's an accurate amount. There's an estimate in the STIPS, Judge. And
Okay.
it was some body damage in a window. And the way the body repair business is now, it's no small damages that I'm aware of.
All right. So that amount goes to Cornelius Meister, $3,609.22 restitution to Cornelius Meister. I don't see the restitution amount for Marlene Pollard. Do you have a restitution amount?
Your Honor, those are for the TIC cases.
I think it's going to be less than $100, Judge.
All right. So, Mr. Ennis, it appears that you have a problem. What is your problem?
I made a mistake. I was going through like a life change. My mother, my child had left me, so I just started making irrational and
I mean, sometimes people leave people for good reasons. I don't understand how that equates to your
I was
being abusive to a dog.
it wasn't that half the statements is not true. Just asked somebody that I had in my life that wasn't the best for me, and then they was doing anything to hinder me. But I'm not trying to minimize or justify my negative behaviors. I just made a crucial mistake in my life, and I'm
No crucial choices.
Yes, ma'am.
So here's my question. They say that how this all started is that it states, victim states he was waiting in the parking lot of the listed location for his friends, just minding his business, waiting for his friends. Victim states he saw a suspect, that's you, chasing after a dog and beating it.
And those some of the things are not accurate, but
Well, is that accurate?
I never I never touched the dog. I was maybe yelling at my dog trying to get it back in the house, but I'm not like, once again, I don't want to minimize justify my negative behavior, so.
Well, I'm going to tell you right now, I'm not going to allow you to have any animals. I don't know why people want to get dogs, get pets. They don't get them their shots. They just keep them chained outside and like, here's some water and some food. Now, there are different standards for dog treatment. Number one, they have to have their vet bills and they need to get seen by a veterinarian on a regular. And if you can't do that, that means that you can't afford an animal and you shouldn't have one.
Yes, ma'am. I haven't had one.
I'm sorry?
I'm so sorry to interrupt you. I haven't had one since.
Well, I will not allow you to have any pets, not even a goldfish.
Yes, ma'am.
Do you understand? Or those hermit crabs that they're so fond of giving away at the fairs. You are not to have a living, breathing, any type of pet.
Yes, ma'am.
The bearded dragons, a bird, whatever it may be. If it has a pulse, if it's living, breathing, all creatures great and small, not allowed.
Yes, ma'am.
I'm not going to allow you to have any contact with minors. And let me just tell you why. Because this is concerning to me that you were beating a dog. Now, I will order parenting classes because you're saying you have a child.
Yes, ma'am.
And once he completes parenting classes, then I'll consider lifting that.
Yes, ma'am.
When's the last time you had employment?
I was currently employed prior to me being here.
Doing what?
Lawn care.
All right. And how many children do you have?
I have 4 kids that have full custody of.
So who are they with now if you have full
My
custody?
significant other.
And is she the biological mother of
Yes,
these
ma'am.
children?
Yes, ma'am.
All right. So I don't know where you're going to be living, but I'm not going to allow you to reside in a home with minors either, because I find this dog issue very concerning.
Yes.
Have you ever had any type of mental health issues?
Yes.
All right. So what has been your previous diagnosis?
I suffer from severe depression and anxiety, and I have anxiety, I have sleeping disorder.
All right. And
currently,
then have you ever used drugs in the past?
Yes, ma'am, but not currently.
And what would those drugs be?
Marijuana.
All right. So as previously stated, the court is finding him guilty. The court is going to sentence him to 2 years in the state jail facility, suspended and probated for 4 years. Taking consideration 2025 PF 12413, 2025 PF 12414. There is to be restitution of $3,609.22 to Cornelius Meister. There's to be restitution, if any, to Marlene Pollard. And cause number 2025 PF 12414. There is to be a TAP evaluation and MIC evaluation in custody. Follow recommendations. There's to be no contact with minors. There's to be no residing with minors. There's to be no contact with animals.
Yes, ma'am.
And for the court, an animal is all creatures great and small. You can't do a mouse, you can't do Michael Jackson, Ben, none of that. You understand?
Yes, ma'am.
So no contact or ownership of any animals. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. No employment as a home health care provider or with minors. 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Probation, I'm going to need field visits 2 times per month until further notice. And if you could have somebody please go to that house check on the children that are in that house and make sure everything is safe with them? Is there anything else, probation?
No, no, sorry.
Is there anything else you need from the,
Are they Pollard?
Pollard, Pollard? Is there anything else you need from the court in order to be successful?
Oh, no.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you're gonna have to do better and we're off the record, find your empathy, sympathy bone and put it at the forefront of your life. You understand?
Yes, ma'am.
All right, good luck to you.
He also had a family violence assault, Your Honor.
Okay. All right, just 1 second. I'm sorry, Mr. Pollard, come back. So who is the complainant in the assault family case?
Her name is.
Might be mispronouncing it, Montisha Nicholson.
Can you spell the first name?
Monteysa, and then Nicholson of Mississippi.
All right, we're back on the record and cause number 2025 CR 002989. And there's also to be no contact with Monteysa, Monteysa Nicholson. And the court will take in consideration 2025 PF 22670.
Yes,
All
ma'am.
right, thank you. DeMonte LaRoberts Williams.
If you're reaching back with the Michael Jackson, Ben,
Huh?
we're reaching back.
Hey, Ben, the two of us need look no more. We both found what we've been looking for. Hello, come forward. All right, state, on this case, do you have all the discovery?
So, Judge, we do. The issue is we've got an unindicted case that's of a substantially higher degree of offense that has not been indicted.
And what case is this? What's
It's an ag assault, Judge.
All right, state, I'm gonna recall this in 30 days. Y'all need to let me know what's happening with the other case, if it's gonna be presented or not. Yes, Judge. All right, Ms. Ferguson, on Robert Williams, if I can have a 30-day reset for discovery. And you need to make sure you're on time for court. Court is at 9 a.m. You understand?
Yes, ma'am.
All right. All right, we'll bring you back on August 19th. Once you sign the reset form, you are excused.
Thank you, Judge.
Thank you. Roman Flores. Oh. All right, how's it going? Oh, thank you. Oh, and you dated it too?
Of course.
Thank you. Thank you. Thank you, Judge. Have a good day. You too. All right, so today is discovery day.
Yes, Your Honor, I have all discovery in the case. There is an offer that's been made by the state. We're requesting that the court set a plea deadline.
All right, sir, how old are you?
30 years old.
All right, Ms. Ferguson, if I can have a 2-week reset for plea deadline date, please. And it's Roman Allen Flores. All right, August 4th.
Thank you, Your Honor. Okay. See you.
All right, everyone else, the court is gonna go on recess. Okay, bring Mount Council up.
I just need to let the court know that I filed a motion for insanity. The
All right, so
evaluation.
I'll have to take that up at,
Yeah.
after recess.
Which has to be brought up again, Jen?
No, Mount Council.
Yes, that's the one.
Oh, then it's not why is it set for a plea if it's for Saturday?
I don't know why.
All right,
So it's been
So-
filed.
all right, Mount Council, what date? Have you already filed the
I have
Saturday?
filed it. Yes.
I've been in jail, June, I haven't been in court yet.
Oh, Miss, you were in court on June 24th.
I broke my house, I'm in that shape, I can't even get out of bed.
All
I
right.
can't even go to the bathroom, and they won't give me proper supplies, they're trying to give me some supplies for me.
All right, well, Miss,
It's prescribed in my home.
all right, Miss Mount Council, you were you were scheduled for court on June 24th, but your attorney was in jury trial in Comal County. And then we brought you back for July 7th. And I believe we had that by Zoom. And so now you're here today. Ms. Ferguson, set it for 45 days. They should have the sanity evaluation completed by then. All right, September 8th.
Help, and I'm laying there, so I'm in such bad shape, and I stink also,
All right, no problem.
and I can't, I'm not that way, I'm kind of.
All right, thank you.
Thank you, Judge.